Completeness. Remember that we are still on the topic of certainty. We have discussed the case of vagueness of the terms. Now we will look at incomplete agreements by discussing two important cases. While discussing completeness as a concept, the general rule is that the courts will not enforce an agreement which is missing essential elements. In May and Butcher versus the King, 1929, the House of Lords held that the agreement was incomplete at the time of its creation as it lacked a price and payment schedule. The argument ran that if you had asked the buyer and the board how much they would pay and receive and when, they would not have been able to tell you. It was accepted that an agreement may leave something to be determined in the future, for instance, by a third party, and still be certain, but it must not rely upon the parties coming to an agreement in the future. On the facts, the incomplete agreement could not be made to work because it contained an agreement for the parties to agree the price at a later date, an agreement to agree. The principle in May and Butcher that an agreement to agree is unenforceable was reaffirmed by Lord Denning in Courtney and Fairbairn Limited versus Tolani Brothers Hotels Limited 1975, where the parties agreed to negotiate fair and reasonable contract sums to pay for the construction work to be done. The construction contract was incomplete and void for uncertainty because the price was to be agreed between the parties at a later date. Another important point came out of May and Butcher relates to the interpretation of Section 8 of the Sales of Goods Act, 1979. Sales of Goods Act 1979 regulates the sale of goods, that is, things such as televisions, cars, and other physical objects. Viscount Dundon, applying Sale of Goods Act 1893, a predecessor of Sales of Goods Act 1979, thought that Section 8 subsection 2 only applied to cases where the contract was silent on the price. That is, where it was not fixed, left to be fixed in the future, or to be determined by course of dealing as permitted by Section 8 subsection 1. On the facts of May and Butcher, the agreement was not silent on the price as it provided that the price was to be agreed from time to time, and so Section 8 subsection 2 could not apply. We saw earlier that this agreement to agree left the contract incomplete and uncertain. So when is agreement to agree enforceable? In Foley versus Classic Coaches Limited 1934, agreement to agree on a price was acceptable when the parties provided a mechanism for completion in the event of their not being able to agree. May and Butcher had an arbitration clause too. If any dispute or difference shall arise on the subject matter or construction of this agreement, the same shall be submitted to arbitration. So what's the difference? The issue in the case was failure to agree, which is different from a dispute. In Foley versus Classic Coaches Limited 1934, the buyer agreed to buy all his petrol from the seller at a price to be agreed by the parties in writing and from time to time. At this stage, the agreement looked suspiciously like the one in May and Butcher, but at a later term provided that if any dispute or difference shall arise on the subject matter or construction of this agreement, the same shall be submitted to arbitration. The Court of Appeal were happy to enforce the obligations under the agreement because the parties had provided a mechanism, that is, referral to arbitration, for completing their agreement if they were unable to agree. Their obligation to pay could be ascertained even if the parties failed to agree because an arbitrator would set the price. Interestingly, the agreement in May and Butcher contained a similar arbitration clause, which was, it is understood that all disputes with reference to or arising out of this agreement will be submitted to arbitration. Viscount Dundon thought that this clause did not provide a completion mechanism in the event of there being no agreement over the price and payment schedule because it referred only to disputes. In his own words, the problem in the case was a failure to agree, which is a very different thing from a dispute. The slightly wider wording in Foley to include disputes or differences arising on the subject matter or construction of the agreement can perhaps justify the different conclusions. Now, Sales of Goods Act 1979 provides a solution if the mechanism for ascertaining the price fails in a contract for the sale of goods. To make it simple, let's look at three scenarios and see how the Case Law and Sales of Goods Act applies to incomplete price. If an agreement is silent as to the price and the contract is for sale of goods, then according to Section 8 subsection 2 of Sale of Goods Act 1979, buyer must pay a reasonable price. If an agreement is not completely silent as to the prices, but there is an agreement to agree on a price at a later date, remember that in such a case, agreement does not give rise to contract according to May versus Butcher. In the third scenario, let's assume that the agreement contains a mechanism to complete price if no agreement on price occurs. In this case, initial incompleteness does not void the contract if mechanism provided certainty. For example, referral to arbitration in Foley versus Classic Coaches, to mechanism in May versus Butcher.